Love to you, love to you. Pray all is well, P-R-E-Y. Honoramus Matris Nostris. Excuse me. Oh yeah, you finished? That's beautiful. Nature. And I mean the first paragraph puts it all on them. Love to you, love to you. Legal obligation under which the United States has charged itself. I mean, you're the authority, you know? Fiduciary obligation, moral obligations, legal duties, fulfillment of understandings and expectations. Trust, responsibility. And take it back. Enforceable fiduciary obligation. This is what they're saying, though. They're saying this. That's my argument with you. Is they're the ones saying it. They're typing it. It's posted on .gov. Frequently asked questions. And then look, and then peep this though. Alaska Native. Look at that. It's clear it's a federal Indian trust responsibility. It's clear that there's American Indians and Alaska Natives. So who's the trust responsibility really to? Again, the enforceable fiduciary obligation. I'm at you because you're the authority. I'm not saying that you're not having successes, you're not on the grids, all those things. I'm saying add fiduciary into your language. Burn them up. They have the obligation. Entails legal duties and moral obligations in the fulfillment of understandings and expectations from us. Look, enforceable fiduciary obligation to protect. Come on. I'm just saying, get into it. Burn them up. Look, the Supreme Court, how they do it. How they do it. Come on. Has charged itself with moral obligations of the highest responsibility and trust. The highest responsibility and trust. I'm at you to put the word into your language and burn them up. They're your agent. It's disrespectful to not make your name known. You heard? Your forebears gave you that name. Right? Okay, so maybe you want to change it. Okay, cool. However you do. You feel me? But it's your name. You make your name known. You're the authority. Period. You're the authority. So of course you're the owner. Of course you're the creditor. Of course you're the principal. You're the authority. It is a trust relationship. It is a fiduciary relationship. It's an enforceable fiduciary obligation. Look that up. Enforceable fiduciary obligation. Come on, let's go. Let's get into it. Right? Right? The phrase, right? Enforceable. Oh, my fingers. Come on. Enforceable fiduciary obligation. Let's go. Web search. Look at what AI does. Right? You got Schneider's and Associates, Understanding Fiduciary Duties, Legal Obligations. A set of legal obligations that require individuals to prioritize the interests of another party over their own. Again, you're the authority. So see the tricks. See the plays going on. You know, I throw the food at you at the highest. Right? Or not the highest, but as one trick, right? Fiduciary duty. Alright? You know, CFPB, what is a fiduciary? Right? Understanding breach of fiduciary duties. Come on. Is that really enforceable? A fiduciary duty imposes on an individual the duties of good faith, utmost loyalty, candor, integrity of the strictest kind, to refrain from dealing? Come on. Come on, you see where I'm at with you. Georgetown University. What if fiduciary obligations are like contractual ones? Look at this, 2016. Look. See that? Look, courts will not enforce. See the problem? Men and women must enforce. Right? Commitments that are, right? Such as a promise to perform an illegal act. Courts will not enforce them. Right? Men and women will not enforce them. Right? Is a fiduciary an actual enforceable law? Right? You can be jailed for breaching it. Is fiduciary duty an actual enforceable law? Now look, it's in Quora. Look at that. NDL. 28 words. Enforcing corporate fiduciary duties through CRIMI. Right? 2010. This article examines the federal government's growing use of 18 United States Code 1346 to prosecute public company executives for breaching their fiduciary. Oh, I didn't even mean to touch that. The fiduciary obligations of public officials. Look at that. This is St. Mary's Journal. Look at how I'm showing it to you. Right? NDL scholarship. Enforcing corporate duties through criminal prosecution of honest services fraud. Right? Right, the abstract. Section 1346 is a controversial but under-examined statute, making it a felony to engage in a scheme to deprive another of the intangible right of honest service. Although enacted by Congress over 20 years ago, the Supreme Court repeatedly declined to review the statute until now in 2009. Justice Antonin Scalia, I'm saying it wrong though, aren't I? Pointed to the numerous interpretive questions dividing the federal appellate courts and proclaimed that it was quite irresponsible to let the current chaos prevail. Since then, the court has granted certiorari in no fewer than 3 separate cases construing the honest services law. The questions before the Supreme Court are of particular interest of public company executives and their professional advisors. Following revelations of massive fraud and management wrongdoing at Enron and other public companies, the Justice Department employed Section 1346 to indict executives accused of breaching their fiduciary duties. Okay? All right? Okay? Section 1346. So let's just go there. Let's just look at that. Right? I'm not even looking at that. You hear me? I'm just giving you fiduciary law raw. But alright, so 18 USC Section 1346. Honest service, right? Scheme or artifice to defraud for the purpose of mail and wire fraud statutes. Okay, so definition of scheme or artifice to defraud. Look. For the purposes of this chapter, the term scheme or artifice to defraud includes a scheme or artifice to deprive another of the intangible right of honest services. So that contract that you're endorsing that has the seller listed as the creditor is a scheme or artifice to defraud. There's your title right there. And then what? And then they played that into saying breach of fiduciary duty. Right? They breached their fiduciary duty by creating a scheme or artifice to defraud. See that?
Yes.
Found them guilty for breaching their duties and convicted under the statute. Traditionally, Delaware law has governed the content and enforcement of executives' legal duties, largely protecting public company fiduciaries from civil liability. Now, with the emergence of honest services fraud as a weapon against corporate wrongdoing and pressure from Congress to more prosecutions, civil and criminal law are trending in opposite directions. Corporate fiduciaries may become criminally liable for conduct that would not subject them to civil sanctions. Furthermore, because these fiduciaries look to state law for the standards governing their conduct, this anomalous development has profound implications for public company governance. This article analyzes the issues before the Supreme Court in light of these jurisprudence to state fiduciary duty doctrine. Excuse me. I jumped. All right. Supreme Court in light of these contradictory enforcement trends. Spillover from federal criminal jurisprudence to state fiduciary duty doctrine is one concern. But overcriminalization and prosecutorial abuse also must be considered. I conclude this article by proposing a statutory amendment that may advance Congress's interest in prosecuting public company executives for serious fraud while limiting federal interference with potentially conflicting fiduciary obligations arising under state law. What'd you say? So now, this is a weapon, is it not? This is a weapon, right? To use against them, is it not? And even though they want to keep it in the realm of quote-unquote public, corporate, everything's corporate, right? Public service is a public trust. Right? So the article examines the federal government's growing use of the title to prosecute public company executives for breaching their fiduciary duties. Because under honest service, right? Right? And look how simple this is, though. Look how simple that is. Scheme or artifice to defraud. So again, I throw at you that. Love to you, Jay. Again, I throw at you, the so-called contract that lists the seller as the creditor. Right? Come on. What we got? Can I get a Verizon? Can I pull up Verizon right now? And that's just an example, right? The loan agreement that lists, the said creditor as a buyer, while the seller is listed as the corp creditor. That's a scheme. Verizon Wireless contract. Retail installment contract. Retail. Or how about, let's look at a car contract, right? You heard, Grandma? It's a broad term, right? Civil Code Dealer 101. Look at that. Right? Finance charge. And automatically. See that? Buyer's name. Right? The words our, we refer to the creditor. Right? Seller in this contract. You see that? You see it? The words our, we, and us refer to the creditor seller in this contract. So is that not? Is this now you look at the document, is it now not an artifice, right? To scheme and defraud. Honest services. Again, how can the seller be the creditor too? Right? I give you self-dealing. Bank examinations, right? I take you to self-dealing, bank examinations. This is your stuff. Again, moral obligations. My conversation with you. That's how I started you off, right? The fiduciary relationship requires the moral obligation from the agent, correct? Your United States thing is getting at quote-unquote public corporate directors. Love to you. Hitting them with 18 United States Code 1346. And I'm just using this example. My conversation with you is you come with the breach of fiduciary obligation. You don't even have to use titles. You understand? That's how fiduciary law, the word itself is the highest regard. It entails the moral obligation. It's the conversation with you. Strongest integrity, utmost, right? Showed you that, right? Right, so the honest service, right? So is that honest? Look at the car contract. Is that honest? The seller is calling themselves a creditor. How is that possible? And listing you as the buyer. You're listed as the buyer. Look, the words our, we, and us refer to the creditor seller in this contract. You already know you're the creditor. I don't need to show you that. You're over here, you're on this platform, you're looking at the page, all of that. You already know you're the creditor. I don't have to show you that. I hear you wrapping your head around it's a fiduciary relationship. It's a fiduciary transaction. You already know you're the creditor. I don't have to show you that. So now see the seller taking your title, playing your character, falsely personating you. Right? Here's what the right? In a scheme, using an artifice to defraud. In the article, right? The build on the article from, where you at? Is it 28 words? Let's see if it was 28 words. Yeah, 28 words, right? Enforcing corporate fiduciary duties through criminal prosecution of honest services fraud. Corporate fiduciary. And corporate, what does that mean? Isn't public service a corporate? So aren't they corporate fiduciaries? You feel what I'm saying to you? Period. So creating a ticket in order to, you know what I'm saying, scheme, right? Defraud. Right? That's what this is talking about. And it uses Enron. I didn't know the government used breach of fiduciary duty for them. I didn't even read up on it to say it like that. So. But, come on. Former Enron CEO Jeffrey Skilling and former Hollinger CEO partner.Black are just two of the corporate fiduciaries found guilty of breaching their duties and convicted under the statute. And I haven't, I'm not even investigating the actual case in them and so forth now, right? 1346 is the statute. 18 United States Code 1346 is the statute. Scheme or artifice to defraud. Breaching your fiduciary duty. So, and the Constitution, right? So I got you 3 claims. Well, the documents breach of fiduciary duty. Then I can hit you with a title. I can hit you with what do I like to use? Let's do breach of peace. Okay, so I hit you with the artifice and scheme. Then I hit you with breach of peace. And then what else do I come with you with? I can come at you with some sort of false personation. Because you're creating a artifice, right? That instrument that's being created to defraud me of my quote-unquote intangible right of honest service. All under the breach of fiduciary obligation. right? Why do I say come with the breach of fiduciary obligation, right? You know why, right? Because your federal government says so. Judicial remedies must be available for the breach of fiduciary obligation. I'm just telling you to title it that. And now look, you can use as well as one of the claims. And then read through the Enron case. Read through the Enron case in reference to the CEOs, and you can lay up any CEO. Because again, it's just a chief executive officer. It doesn't mean they're the owner of the company. Right? But let alone to sit in front of the said representative, the said fiduciary at the company, and they're putting you down on the artifice. Where is it at? What I got? Car contract. I thought I had a particular one selected. No, I got this car contract. What did I do? Here we go. Oh, dealer 101. Okay. I was looking at it. That's what it is. Dealer 101. California Civic Code and conditional sales contracts. So listen, they're creating this shit knowing what they're doing. It's on you to call them out on it. Look, the seller cannot be the creditor. Accept that. I need you to accept that right now. There's no way that the seller can be the creditor. They're self-dealing. They're scheming. They're breaching their fiduciary obligation, creating an artifice that defrauds you. They call you the buyer, knowing you're the owner, and then they're scheming, taking the character title of creditor and breaching the fiduciary obligation. That's where I'm at with you. You heard? You're the authority in every contract. You're the creditor in every fiduciary transaction, so forth. It's all fiduciary. Moral obligation. Period. Moral obligation of the highest. Look at what I'm showing you. Really wrap your head around that. Correct. So see the conversion. See the conversion, because they not even going into the court and having a hearing and then getting the proper authorization and order and etc. to do so. Not even getting a judgment to do so. Just a scheme in itself. Right. And that's a scheme in itself. Right. Throw the lien on you. These things. Correct. Again, the contract and business arrangement is between a creditor and a seller. So how in the hell is the seller being the creditor? And the seller has the fiduciary obligation to not engage in any fraud or scheme, and to call themselves the creditor in a transaction is ridiculous. So now see why buyer doesn't mean anything. See why buyer doesn't mean anything. They make sure they let you know. Look at the play. The words, our, we, and us refer to the creditor seller in this contract. Or upon any assignment, its assignees. The words you and your refer to the buyer and co-buyer, if any named in the contract. If any named. Yeah, so I can still get you right back there. That's why I'm talking to you like I'm talking to you. You're the authority. There's no way around it. Now they're scheming and flim-flamming. Correct. Again, you're the creditor. You're crediting their device with your signature. So, yeah, alright, where I'm at, 30 minutes. That's it for me. I just wanted to pop in on that. Again, you're the creditor. Look at the seller manipulating the document. You know what I'm saying? Your government, right? Your fiduciary used 1346 to articulate the breach of fiduciary obligation. Intangible right of honest service. To deprive you of that. So, and I showed you with the 28 words. That's where I got the MRI information from. Reading the NDLS, Notre Dame Law School. Right, see it flickering. With the 28 words, enforcing corporate fiduciary duties through criminal prosecution of honest services fraud. So, you see how I'm talking to you about it? Again, you're the authority. Right? Growing use of, again, an instrument document created to scheme. That's what those contracts are. That seller's self-dealing. And then they're buying the contracts from so-called attorneys who are drafting this stuff up. So, yeah, alright. Well, I appreciate you tapping in. Just wanted to build with you on that. You're the sovereign authority in a fiduciary relationship. You're known as the creditor in every contract and business arrangement. The seller has a fiduciary obligation to not engage in moral turpitude. Denying you honest services is moral turpitude. Honoramus matras nostros. Fiduciary law is it. Love be with you.